Hello and welcome to the meeting of the Consumer Debt and General Civil Subcommittee of the California Paraprofessional Program Working Group. We'll start by calling the roll. Brynelson,
Present.
Fleischman,
Here.
Hamilton,
Present.
Hartston,
Here.
Robinson,
Here.
Shining. I don't believe Carolyn's joining us yet, and Judge Yu has said she's not available for this meeting.
Carolyn's actually a
Oh,
guest.
she's okay. Let me bring her into the meeting. Okay.
Hi, Carolyn.
Hi, Carolyn. So I'll just add you as present to the roll.
My puppy has decided to go in and out and in and out and in and out right now.
Okay. Should we see if anybody else, we have a couple of more attendees. If anybody wants to make public comment, you could raise your hand and do that now.
I don't see any hands raised.
Okay. Let me pull this up. Just a couple of quick slides to orient you all on decisions that have been made to date as we move into then talking about how you want to proceed. So this particular subcommittee combines two previously distinct ones, the Consumer Debt Subcommittee and the General Civil Subcommittee. So what you see on the slide here are all of the areas that the Consumer Debt Subcommittee considered, and these really came from the Justice Gap Study data. And I've indicated in the right-hand column my understanding of where we are with respect to each of these issues. And I say that because sometimes our memos do not exactly jive with our resolutions, which is something that I think we're going to need to get better at. But this is my understanding, is essentially most of the areas under consumer debt were excluded. And we've got three here that are remaining under consideration: creditor collection agency harassment, wage garnishment, and utility cutoffs or billing disputes. So I'll go on now and say for civil, there was a slightly different methodology, not slightly, a very different methodology for identifying all of the possible sort of sub case types under civil. We use the GIPSIS Superior Court data categorization, or the categorization scheme. And that's how we came up with all of those areas on the left, like what is civil? Here's what we're talking about. And the civil subcommittee made decisions that you can see on the right, or made recommendations that then went to the working group last June. Hey, Steve, go ahead.
I was just going to say, when you get down to enforcement of judgments, that's enforcement of judgments on behalf of workers who have wage orders that employers are not paying.
Okay, and I think I clarified that in a subsequent slide, but okay.
No problem.
So either the some of these issues were addressed by separate subcommittees, as you can see. Some of you are on these other subcommittees, so you know that. And there were some decisions to include or exclude or keep considering. So here I've actually inserted the resolutions, which, as I said, are slightly different than some of the language in the memo. And this is where you get, Steve, to your language.
Yes. Last bullet point in civil.
The last bullet point down. And in consumer debt, the resolution simply speaks to what was excluded, not what is continuing to be included. So that's a little point of confusion. But where that leaves me is here, that I believe these are the areas for this combined consumer debt and general civil subcommittee to consider. They're here on the screen. So if anybody disagrees with that or has a different recollection, I think it would be good for us to clarify, just as an initial matter, what is the scope of our work here? without going back, you know, we want to be respectful and mindful of what the working group has already decided, but we want to be accurate.
So can I ask a point of clarification? So I think one of the first things on the earlier slide was creditor collection agency harassment.
Mhm.
Was that supposed to be included or excluded?
To
It
be
was supposed-
decided.
It was supposed to be decided, but here is how it actually came out in the resolution. Representation of debtors in enforcement of judgment proceedings and advice and representation related to debt collection.
Okay, just to be clear, I think the advice and representation related to debt collection could be much broader than debt enforcement proceedings. There could be, you know, harassing calls and, you know, showing up at somebody's work or calling somebody's son. So I believe that was all supposed to be included for further consideration.
For further consideration, yes, I agree with you, Amos. We never came to a decision whether to include that like the other items.
Right, because I think that's different. When a case has been filed and there's actually enforcement of a judgment, that may be a kind of a separate but related topic.
So Amos, you're saying creditor collection agency harassment should go here as a separate, oh, let me, I was trying to edit it on the screen, that didn't work, but should go on as a separate row, essentially. Let me.
So in my mind, I think of it as separate row. I don't mind if it's included in the same topic, as long as that is broad enough to include, you know, creditor harassment, basically.
Okay. Anybody else have any comments?
And just to be clear, I think those two things came from the two different subcommittees, right? One was the debt collection from the debt collection, and the other one was the enforcement of judgment from the general civil. So I think we're just combining those two recommendations together.
Almost correct. The representation of debtors in enforcement proceedings came from old general civil. Then the two committees got combined and creditor harassment got hung up in extended debate in the combined committee. Amos agrees. Okay.
Yeah.
All right. So what I'm hoping we can accomplish today is simply, this is like a planning meeting, identifying what information do you need and who do you need to hear from in order to get to a place where you can make a recommendation to present to the working group in April on each of these areas. And then if we can talk about ideal sequencing of the topics. And I, put like an asterisk around that because, or air quotes, because it is somewhat dependent on how quickly we can get the information that you all say you want, or who we can get to come speak. But it would be helpful to hear what your ideal sequencing is. Carolyn, did you have anything else? Did I forget to say anything about what we want to get out of this today?
No, I think I've learned, and we learned a good deal in the employment subgroup that met on Tuesday, I think it was, or Wednesday, where we had some of this process, gone through, and rather than necessarily debating the definitions, there's a lot of things with regard to the debating of the issues and the scope. And I have a lot of views on this, as a lot of, if for and against, but I think you were right. The way we did it in employment to save time in the short one is to talk about the planning. And we did that in employment after we sort of shook out kind of where we were going. And then we have 2, maybe 3 more meetings where we can get that further debate and listen to people. So is that kind of where, I know Judge Yu did a great job. I could hardly live up to her demeanor and her judicial temperament, but that's sort of what you had in mind a little bit. And I see Steve has his hand up.
Yeah, is the goal, Leah and Carolyn, is the goal out of these meetings simply to identify the substantive topics, or is it also to define the scope of work that will be permitted, including in-court representation? I sort of understood the in-court representation somehow got sidetracked to either a separate committee or a separate discussion.
I have something in my throat. The in-court representation, the full working group is going to come back to that conversation on March 26th. And at the conclusion of that meeting, what we expect to have is a default position across all practice areas. But then there will be an opportunity for each subject matter specific practice area to deviate from the default position. It just will need to be justified. That's kind of the process that Justice Petru and Judge Rubin and I have come up with, that there's a default position for the paraprofessionals writ large, but there will be the opportunity to deviate from the default. So I think this, because that conversation happens March 26th with the full working group, the timing works for this subcommittee then to address that, but I would say not before then.
You just answered my question. It sounds premature.
And Greg?
Yeah, I just have a question. I may have lost it because we are just coming back to these topics, but what is the rationale for allowing paraprofessionals to enforce small claims court judgments, but not any judgment up to $25,000? Why are we only allowing them to enforce wage and hour judgments up to $25,000?
I can answer that. Those two came about in sort of different ways. The concern about limiting it to limited jurisdiction cases is a general concern. And I don't recall if it was the Adels report or another report, but it basically asked lawyers, what was the most important course you took in law school? And one of the top subjects was civil procedure. And where are the areas you can mess up the most? And the answer was civil procedure. So the idea was limited jurisdiction courts have limitations on what can be done. Basically limited discovery, no special demurs. I think summary judgment motions are allowed, but we'll deal with that when it comes to the course of the scope of the representation. So the idea Erica and I came up with was, let's try to limit this to limited jurisdiction cases. I think enforcement of small claims court judgments was simply a separate category that came up. And the answer was, yes or no, and it was yes. But the idea was to try to limit representation to limited jurisdiction where there are fewer pitfalls. In the back of my mind, part of that was also, at the time, we were discussing a $25,000 bond. While I understand we've now decided to increase that to $100,000, that was part of the thinking. The problem is, once you go outside limited jurisdiction court, it's just unlimited. And so, other states, like from what I can figure out, Arizona and Utah are both limited to what we call small claims court, $10,000 and under. So that's a long way of trying to answer your question.
That all makes sense to me, but I still don't, I guess I'm still struggling with why we're only allowing them to enforce wage and hour claims in limited jurisdiction cases, not other limited jurisdiction cases.
Because banks and other people, other creditors don't need lower cost attorneys to represent them. What we heard from Judge Buckley in LA Superior Court is that, generally speaking, the creditors, meaning financial institutions and banks, are represented by highly specialized counsel. They have counsel. The people that need help are the debtors in those cases. And what came up are workers who go through what I'm told is something called a Berman hearing, get an administrative ruling from their employer, and the employer is not paying. Because there are no statutory fees attached to that, they need help getting those administrative judgments paid. And so I was convinced that should be included. So on the debtor creditor side, it was the purpose of the program is not to help banks get lower cost legal help. It's to try to help debtors, individuals. Did that answer your question?
Not quite, because I think individuals can be debt judgment creditors as well outside of the wage and hour context for judgments under $25,000. I'm thinking of, I mean, in housing, a landlord may owe money to a tenant, and that's still under $25,000.
I agree with you that
car dealership, and as an
Greg and Steve, I think we're getting a little off scope. What I'm going to ask Greg, because Amos has had his hand up for a bit, is to think about it as in terms of what information would you like us to bring forward, or who would you like to hear from to help flesh out this issue of, like, should it in fact be expanded beyond the scope that you see on screen, and what would you need in order to make that decision?
Well, and I would add, Leah, and then we'll get to Amos just really quickly. There's nothing in the process of this subcommittee and the other subcommittees that says or does not say we can jump ahead of the working group's consideration of those 4 topics, in court, out of court. You know, we can go in, and it sounds like we're going to go in and think about in court, out of court, half in court anyway, and we don't want to beat them to the punch, but it's okay to go ahead and think about these things, Leah. So we may be having future thinking in our recommendations. Will that be okay?
Sure. And like I said, I think on March 26th, the full group is going to take up in-court representation, and this subcommittee will meet again after that. So I think it's not even necessarily jumping ahead, because you'll be informed by that process.
Okay, Amos, you've been waiting.
Yeah, thank you. So I have 3 quick things. One is on this enforcement of judgment. I'm interested to hear what the family law groups said about family court judgments, if paraprofessionals are going to be allowed to help enforce like a child support or spousal support judgment. That might be relevant. I'll quickly say my 2 other questions. Well, one other question is the 2 areas, name and gender change and civil harassment, were recommended for inclusion, are not on the list. This list, is that because they're going to be taken up by other committees?
Civil harassment was taken up by family. Well, there's a new, I think, violence prevention subcategory. Name and gender change is one that was sort of easy out the gate. The working group said, yes, it should be included. We have yet to go through the process in any subcommittee of just delineating what that work is. So it is a to-do that doesn't have a home right now.
Got it. And my final point is actually finally to answer your question about information. My recollection and my review of the report suggests that Ms. Farron from Public Law Center did have some suggestions about specific tasks that might be appropriate for a paraprofessional to perform with respect to debtors. And I'd love to hear more of her input on that.
Okay.
Oh, and we did sort of skip over whether there's any public comment at the beginning, Leah. Did you want to offer that up?
I think I did ask it, maybe when you were transitioning over. We could ask again, or I don't know, can you, Linda? I can't really see anything right now. I don't know if Linda can.
Hi, I'm sorry, I was looking at something else, but what was the question?
To see if there's any public comment right now, but because I can't see the people. In the meantime, do you want to have Steve go, Carolyn?
There's no other public comment right now.
Okay,
And does somebody know the answer to my question about family law judgments?
Stephen Hamilton should.
What? Give me the exact question again.
If the family law subcommittee considered whether or not paraprofessionals should be allowed to help enforce family law judgments like support judgments.
Yeah, we addressed enforcement of judgments within the family law courts. And
To recommend that for inclusion?
Recommendation was to allow them to do it. But with I take that back. The one exception was contempt because of the quasi-criminal nature.
Okay, Steve, did you want to point out something?
Yeah, so Leah, in response to your question, looking at this list, I think the most controversial one is going to be creditor harassment. And so what I'd ask staff to pull together is the same information we asked for in employment, which is what actual data is there out there that people that are harassed by creditors cannot hire a contingency attorney under one of those various statutes that provides for fees. And relating to that, how many people with creditor harassment claims are representing themselves pro se in court as opposed to having counsel? What are the actual statistics or lack thereof on those issues?
You know, I can say with a great deal of confidence that we don't have that data. So
Okay.
not we, the state bar, I just don't think it exists. I know that the.
Well, I
court-
know it's not in the Justice Gap study.
No,
So,
not that, but even the court self-represented litigant data, it doesn't break down the civil case types to that degree. So, and that's the only place we'd get that kind of data. That's not anecdotal.
I
So
understand. I mean,
Yeah.
I take Judge Buckley at his word, and it makes sense to me when he says there are lots of debtors who are self-represented because they can't afford counsel. That makes sense. If you can't pay your credit card bill, the idea that you can't hire a lawyer makes sense to me. But
So
if you
let me
have an
just-
affirmative claim for relief, and there's an active bar out there of attorneys representing you on a contingency basis because fees are available, then I don't see the need absent some data suggesting otherwise. And I'm guessing Amos is on the other side of that.
Well, let me just jump in. This is Justice Petro. I can't do video right now. I presided over hundreds, if not thousands, of these cases. And basically, the debtor was never represented. It was, one in hundreds where there would be representation. And of course, it's not, as you noted, it's credit card debt, it's student loan debt, it's all different kinds of debt. I will also say I saw many circumstances of unrepresented debtors being taken severe advantage of, in particular if English was not their first language. So it's I'll call it anecdotal, but it's firsthand experience that there is a significant need.
That is 110% consistent with what Judge Buckley said. The only thing I would add to that was Judge Buckley referred to the attorneys representing the banks and the creditors as being quite sophisticated, which I think was a polite way of him saying they know how to go in and get pretrial writs of attachment, things like that.
Yeah, it's the type of practice area where, people don't tend to do it as one-off. And so it was my general experience that on the plaintiff side, it was firms who often exclusively did this kind of work. And so certainly we're very, very good at it. And good. There's a lot of cut and paste that happens, but they know what they're doing and they know the procedures and the steps to move it forward. They're certainly very familiar with, in particular, the default proceedings.
And you were just more articulate in explaining why we included that on the on the debtor side than I was a few minutes ago.
And Amos, if your honors is finished, and maybe Amos has got his hand up still.
Yeah, I just wanted to add as well that for creditor harassment, these don't always end up as affirmative lawsuits. The idea is debtors are harassed and debtors have rights not to be harassed. There are consumer protection statutes. So representation in this kind of case doesn't necessarily mean an affirmative lawsuit, but it could be a letter saying you're violating, a consumer protection statute that you can't call this person, you can't call that person, can't tell my workplace, can't tell my family, you can't collect on that debt because it's beyond the statute of limitations, et cetera, et cetera. So these aren't necessarily in court representations, but there's a lot of debtors out there that probably need some legal advice.
Yeah, and I think too, just to kind of bring us back to where the employment subcommittee went, sort of the people who can really bring us in, data's good, but the people who can really kind of illuminate some of the things that Gregory expressed as a concern, which are some of the laws that need to be changed. I was thinking that it might be fruitful to have someone in these narrow categories from the California Attorney General's office, or maybe even LA County, some of the areas that the Los Angeles County city attorney or the city attorneys do in their consumer division. So I don't know, Amos, if you have any ideas or names of people that you could give to Leah, or if that would be fruitful, but maybe the other people have thought through. I've thought this through because I sat with the employment committee. We sort of talked about it. But do people
Well,
sort of have a thought about that?
I am in the consumer protection section of
I
the
thought so.
California Attorney General's office, but I have to again clearly state that I'm not in that official capacity on this working group. So I don't represent the Attorney General's office on this, but I'm happy to share sort of my thinking of that. That's why I say creditor harassment goes well beyond affirmative claims. There's consumer protection statutes out there that don't necessarily require an affirmative litigation, and a contingency lawyer wouldn't touch. Just somebody who's been getting harassing calls.
You're muted, Leah.
Is that something that you think someone from your section could talk to us about? I know it's a little awkward for you to be a subject matter expert and on the committee.
I'm happy to check, and I'll talk with you offline about what we're specifically looking for. And I agree that this district attorney also has a consumer protection section as well.
Okay.
I think we also, didn't we hear from a judge who presided over a small claims court? Or wasn't that someone who, again, a limited judge? Or I do know the judges in Chatsworth, I think, in Los Angeles County have sort of been assigned. There's one or two courts I think they've moved these things to. So that might be someone to look to.
And legal services, definitely, there's several legal services organizations, both in LA and in the Bay Area, that have practice areas around this.
Okay. And around this, we're talking about creditor harassment specifically right now?
Right, debtors' rights and consumer protection.
Okay. And do you all agree with Steve that if we can take this as the first issue, we should?
I wasn't speaking so much to the ordering, just, the rest of them we've either decided or I think based on prior meetings are relatively easy to decide.
I also think the creditor harassment will be very related to, and probably the same speakers, with the representation of debtors and enforcement proceedings, because it's sort of the next logical step.
Yeah, I see those going together. Okay. Greg, have you thought about what would be helpful in terms of this question of why is the enforcement of judgment limited to small claims court judgments, and then limited jurisdiction representation limited to wage and hour?
I don't know what would be helpful. I mean, it sounds like some of the experts that you're already lining up might be able to speak to that. I just don't know intuitively that we have individual judgment creditors out there who have small judgments, and they're probably having a hard time enforcing them. And I'm just wondering what the rationale. I'm sure if the proposal comes to the court, that'll be one of the first questions I get on that particular topic is I don't understand this limitation. Why are we only addressing wage and hour judgments and not other judgments that individuals may have under that dollar amount, of course. And I understand the position of perhaps not wanting paraprofessionals to represent entities, and that's something that we in the regulation subcommittee need to still take up, whether or not any organizations can be represented by a paraprofessional. But certainly the idea of this program is not to provide additional representation for banks or financial institutions.
Greg, if you are aware of any data about small individuals being creditors and needing legal help, I would certainly keep an open mind. But my hunch is it's mostly anecdotal, and we're going to have a hard time drawing a line between the mom and pop who loaned a friend $10,000 and a bank trying to collect the $10,000 other than individual versus non-individual entity.
I don't know if you would have a hard time drawing that line, Stephen. I mean, if we have a rule that they can't represent banks or financial institutions or for-profit corporations, that ends the entire issue right there.
Do
And
we want them
especially if you
representing?
also have the dollar limit of $25,000 or less, plus the restriction.
You're making inroads, but what about the, landlord who's just looking to get cheaper representation? Do we want them representing an individual landlord, kicking people out of apartments?
That is a question that you as a group will need to deal with. I mean,
Okay,
that seems to be an open issue right now, whether or not landlords will paraprofessionals be allowed to represent small landlords. And there are ways that you can build in restrictions so you're not, representing landlords who own multiple properties or corporations that own, residential real estate or what have you.
I'm open to discussing all of those issues. I just wanted to explain the background to you of how we got where we did.
Understood. And just so you know, what I am doing, and I will probably be doing this more and more as these recommendations get more specific, is identifying gaps that the court is definitely going to want to have some explanation around as to why we've drawn the line here. And I understand the rationale you gave me, but that doesn't fully explain the restriction.
Okay.
Now, Steve, I have a question too, since moving on beyond creditor harassment, is the difference between the representation of creditors and wage and hour claims and wage garnishment and that overlap what we have in the employment arena. I understand that I came in a little bit late on the general civil, and I think some of that had already been discussed. So, and I know people who are plaintiffs' attorneys and people who do look at some of the issues that Amos mentioned. There are those class actions, there are triggers, there are larger things that, again, we don't want to impact or diminish. And think of that role when a paraprofessional has to, say, you've got other rights here. You can go to an attorney. Here's sign here in my release in my contract. So, what is the if you can remember, Steve, and then maybe we can think through, because I know we had two very experienced consumer attorneys come and people who taught, I think, Cal Western this courses in this. But just to kind of, again, to distinguish and narrow down who we want to come present to us.
Well, the common denominator was representing workers and not employers. So if someone is if someone is an employee and they are having their wage garnished, we heard from someone from one of the public interest organizations, and they explained how complex that is, and that's an area where people don't have a lot of money. Their livelihood is being taken from them. And that seemed like an area for consideration in the program. The same thing with representation of creditors and wage and hours. These are workers who have been adjudicated to be owed money, and because there are no statutory fees, they have trouble getting paid and hiring lawyers. So I can tell you that's the common denominator from my perspective.
I wonder if the representation of creditors in wage and hour claims and limited jurisdiction cases, if you all should refer that to the employment subcommittee. I'm saying that because they are taking up wage and hour squarely, as you know, Carolyn. In fact, we're going to focus on that entirely on Tuesday. And it's a bit of an artificial bifurcation that would leave Greg's a question potentially for this group, which is representation in limited jurisdiction cases generally, for this group to consider.
I guess I think Steve kind of clarified for me, it may or may not be relevant to that group. I was, the term wage and hour might be a bit, who's owed the wages and the hours. This is somebody else is owed the wages and the hours. It's you're taking it from the person who's already been adjudged to owe it, unless you had a cross claim. You sue for discrimination and you want your wage and hour. And I guess it's a triangle. Am I wrong, Steve? This is not the same back and forth, is it?
Carolyn, my understanding was when representation of creditors and wage and hour claims came up, it was a worker has an administrative ruling from the appropriate administrative agency saying, my employer has not paid me.
Oh,
And they are trying to get paid, and the amount in controversy is not enough to hire an attorney, and there are no statutory fees to incentivize attorneys to take those cases.
okay. Then I
But
think
Judge
that's
Buckley-
really what we were doing over there.
Well, yes and no. I mean, the issue of Berman hearings came up in employment, and Erica brought up this issue, and I said, no, we don't need to address that issue because we already approved it in general civil. So I don't care. If you want to kick it over to employment, that's fine.
So I like that idea. I don't know if you need a motion, but I think we will still need to deal with the question that Greg raised, which is if we're allowing for enforcement of judgments, why only small claims court? Why not also limited civil? So I don't think that avoids that question, but I do think if we could put the wage and hour issues over into employment, that might be better.
That's fine. I'll say it again. Enforcement of small claims judgment was listed as a separate category of problems under general civil. And because of the amount involved, we were okay with it. There was never a discussion of allowing enforcement of judgments generally because of the reasons I discussed, that we didn't want this program to become representing banks. And that's where most of that happens. The idea was small claims court was deemed to be a separate category. So, okay, we can deal with that.
So
Julie-
maybe for
Julie's-
what information we need, can we just bring in some people who can give us details about what is involved in enforcement of judgments, and if there's significant differences for, depending on the amount, 10,000 or less or 25,000 or less?
Julie's had her hand up for a while. Julia?
Yeah, I just, since we've taken a break and now that you've given me the background of what's going on in employment law, I'm comfortable making a motion saying that we refer that to the employment law subcommittee, because I think we're much more looking at general civil. And it really sounds like this is something that is covered specifically by that other subcommittee, and people who want to participate in that or have more expertise. I'm for it if we're ready to make a motion that way.
Question, are you also recommending moving wage garnishment to employment?
I hadn't thought about it, but what does the group think? What do you think?
To me, if we're moving one, we should move both.
Agree with that.
Yeah, I mean
I'm
just-
open. Go ahead.
I just think that with the amount of work we're putting in, I would hate to see duplicative work or something that could be specifically addressed by employment law, and that they are anticipating that these issues would be before them, rather than, and we have so many general scope things. Like, I really think this thing that Greg has brought up and that Amos has talked about, I think we should have a bigger discussion on the enforcement of judgments. That to me is where we should be focusing our time in the general civil or consumer debt area. But I am comfortable sending that to employment law if others agree.
And Amos?
Oh, thank you. Yeah, so I don't mean to divert our attention, but on the representation of debtors, I also remember that discussion had a big part of it was defense versus affirmative claims and state versus federal court. So I think we need some speakers to talk about both of those things. The defense of debtors and enforcement proceedings and how much that involves affirmative counterclaims and the issues with respect to state versus federal court. And for what Julia's point is, I agree. I support moving those issues to the employment if employment wants them.
Oh, Leah, you're muted.
Need a formal motion. I think maybe if anyone on the subcommittee objects, I'm not, if wage garnishment feels not like employment law to me, but I'm no expert.
I was thinking that too about the garnishment, because each of these categories seems like a small individual who is fighting a much larger entity to get money out of them. And in wage and employment, it's sort of the reverse. In the representation of creditors and wage and hour claims, that I think directly, the way Steve explained it, is part and parcel of handling your wage and hour claim. And because there would, if you're in court, if you're a limited jurisdiction, there may be a counterclaim against you. There's just, there's ways. And if you're bumped up to unlimited, there's very likely that's a counterclaim situation where your employer's countering what you say, they say, for people who are, salespersons who get, real estate people who get not contingency fees, but they get paid bulk, or they have some kind of employment dispute. I think that one's good. I'm not so sure about wage garnishment though. But, we kind of digress a little bit, because one of the other thing I thought was, some of the people we're talking about, I think Amos talked about, these are legal experts. They're going to be lawyers. And so I think one of the things that I know, Judge, you said, and said a couple of times, and Ira thinks the same, we need to hear non-lawyers. And so, I've asked some of my friends to think about who they would bring as non-lawyers. I would bring back some of the lawyers that I brought, but I think that, again, that's, I don't know. I don't think they spoke in front of this particular group. I'd have to go back and see. Are there any thoughts about non-lawyers we can come in and talk about the things that were on the table? It's pretty technical. Steve?
Yeah, I'd like to hear from people representing the banking industry. I mean, again, we tend to hear only one side of this, but in terms of creditor harassment, we should be hearing from both sides. So whether that's the California Chamber of Commerce, CJAC, or some banking organization, I feel we should be hearing from both sides.
Julie, you look like you're puzzled.
Yeah, I mean, I don't know. I have my own experience of what I think of when I think of creditor harassment, and I don't think I need a bank to tell me what that looks like. I don't know. I don't know that it's necessarily at this point coming out of banks per se, or what person or representative from a bank would be our person most knowledgeable. But I think we're talking more of, debt collection agencies are the ones that usually get assigned these claims, and that becomes their, portfolio of work. They're just trying to collect money on behalf of the original loan. And I think those are the folks that are going to tell you, if they were honest, how they acquire those cases and what is their approach to trying to get paid. So I don't see that big banks as being quite helpful in my deliberations. I think if we could get the debt collection agencies, they're the ones who I think is going to be on the other side.
Fine.
Amos, what do you think?
Well, I don't know that I mind either way if we hear from them, but I think there are consumer protection statutes that we just need to know what tasks are appropriate. There are laws and rules about what debt collection is allowed and what's not. So I think the lawyers that practice in that area probably cover it for me. What I was going to say is on wage garnishment, if that is staying in this group, I would be interested in hearing very specific details about what's involved, both in getting a wage garnishment and in objecting to it or removing it. I suspect that is probably similar people to the representation of debtors and enforcement of judgment, because they're very related topics. But I think there are some specific rules about how to get a wage garnishment, and if you're on the other side, how to object to it, that we should understand.
Okay, I see Steve's hand up, but before, can we just, if anyone objects to moving the representation of creditors in wage and hour claims over to employment, can you wave your hands? See anyone? All right, so we'll kick that one over. On wage garnishment, but at the end of this call in 12 minutes, I'd like to decide what we're going to do. But Steve, you had your hand up.
Yeah, I just want to respond to what Amos said. We heard from someone it was either public counsel or BEDSEDEG or one of the legal organizations about wage garnishment in painful detail. It is, I would summarize it as incredibly complex, but like name changes, after you do the first 2 or 3, you probably get the hang of it. And the issue is being able to file exemptions and forms in Superior Court to say that that the wages are exempt, and here's which one of the 17 exemptions applies. If you want to do it again, I mean, look, the whole way these issues have come up with the committees bouncing around, Amos, if you want to do it, that's fine. I'm just trying to cut to the punchline. It was extremely long and tedious, and half of us have already heard it.
We heard from Bonnie Huff. I think that's how you say her last name, from Judicial Council Self-Help Court, who is one of the organizers or the managers of that group. And that was a long time ago, but I don't know if Leah, if she could come in and speak on that particular issue, because I don't know, is that a self-help group, self-help court clinic thing that they deal with? I don't know.
I don't remember Bonnie speaking on this, but to Steve's point, just to kind of accelerate the conversation on wage garnishment, I think it might make sense for the staff team offline to flesh out a task list with one of those experts that we spoke with before. And so that the next time we bring this back to this group, it's with the fully articulated task list and some recommendations from these experts about what a paraprofessional might or might not do. And then you have that in a Q&A with the expert to kind of reach a decision.
That's a fantastic idea.
Handle wage garnishment that way. Can I ask a question about this enforcement of judgments issue? And this would just be a dumb question, but are we just assuming, or we're precluding paraprofessionals from assisting any litigant in getting the judgment in the first instance? So they're excluded, but they may be able to come in and help with judgment enforcement. Is that what we're saying here?
I understand.
Obviously, no lawyers, no representation, but limited civil, you can have representation.
Yeah, and that was part of the small claims court issue. Was in California, unlike other states, we don't allow lawyers to be involved in small claims court. But once somebody represents themselves in small claims court and gets a judgment, enforcing that is incredibly complicated, and they need legal help. In contrast, the hearing in small claims court is, at least in theory, supposed to be very informal, and everyone represents themselves. Everyone's got an even playing field. So it was represented to us that there are people that represent themselves in small claims court, win, get a judgment, and then they need help enforcing that judgment.
Right. But
go ahead.
What about limited jurisdiction civil, where you can have a lawyer?
Where you can have a lawyer, if you're talking about representing creditors.
Not creditors. So once we move the wage and hour, I just want to make sure I understand what we're doing. Once we move the wage and hour piece over to employment, is this group done considering any representation in limited jurisdiction cases, period.
Well,
And now-
the first one is supposed to be limited to limited jurisdiction.
Well, that's why I think, and then, yeah, I'll just real brief. That's why I mentioned earlier on, are we really talking about the substance of things? Are we overlapping into that decision that is kind of pulled out to the big group in the 4 factors of the 4 ways paraprofessionals can work in court, in court, out of court, kind of in court, kind of sort of in court? Maybe we don't need to think about that, or is this endemic in what we're thinking about this, I mean, it's general civil. I've always wondered what that meant. Amos?
So is it correct that wage and hour claims go through an administrative hearing, not a limited jurisdiction court? Or can it go either way?
You go either way.
Okay, so yeah, I don't think that moving it addresses the issue that Greg raised before, which is if we're going to allow paraprofessionals to enforce judgments, small claims judgments and family law judgments, why wouldn't we also allow them to enforce limited civil judgments? And I think we will need to grapple with that.
I'm going to reach out to somebody at the Judicial Council to see if I can find some statistics on the number of self-represented litigants in limited jurisdiction cases on an annual basis who perfect a money judgment.
Thank you.
Because I think that will at least give us, if they have that information, it may be on a countywide basis, I'm not sure, but then we can, because now I think you're starting to struggle with the same thing that I'm struggling with. Once you have a judgment from small claims court, or you have a judgment, a money judgment from a limited jurisdiction case, it's a judgment that needs to be enforced. I'm struggling with why we are saying a paraprofessional can enforce this kind of judgment, but not this kind of judgment. They're both, to me, small amount of money. It's a small amount of money. If we're really worried about them representing financial institutions, there's a better way to approach that, I think, through the rules. So I just want to make sure we at least think it through. I'm not advocating for it. I'm just want to make sure that the group has thought it through.
Juliet, we only have 6 minutes or a few minutes. So Julie, did you have any more thoughts on who we could bring in to kind of make our discussion fulsome?
No, the only other thing I would say is that I agreed with what Greg suggested, in that, you know, we right now kind of have an idea that we're just now talking about who we're bringing in for the next round.
Okay. Well, there's a lot to contend with here. I'll do my best. Carolyn will work up an agenda for the next meeting based on really who we're able to bring forward and what data we can get. And Greg, Linda and I will send you the not to be made public self-help data that we did get from Bonnie. It does not have that level of detail, but perhaps through your sources, you can get something drilled down even further. But we'll send what we did get.
Sounds good.
Greg, while you're looking for that information, this may be impossible, but you can have a self-represented entity where you have an in-house lawyer, say at a collection agency. And I just would hate to get statistics that includes them along with a true individual debtor.
Well, I think we do distinguish in court records between an individual person and an entity who's represented by counsel.
Okay, good.
Okay.
So those are all those fun civil cover sheets we attorneys have to fill out as accurately as possible.
Exactly.
Yep.
All right. Anybody have anything else? Okay.
Time to move on to health.
Yeah.
Yes, we'll see if several of you in just a moment in the next room.
Okay. Thank you. Bye.
Have a good weekend, everyone.
Yep.